Clients often ask me, I've been involved in an accident and I'm a passenger and 2 cars were involved. Can I collect from both cars? And the quick answer is, well, yes, depending on the responsibility of each car. But there are such specialized laws. So let me get one thing straight. If you have a case that's worth $100,000, okay? You cannot collect $100,000 from each car. That would be $200,000, okay? You can collect a total of the value of the case. Who it comes from, you can collect from either or. When I say either or, that's an interesting question. 2 vehicles involved in an accident. This is New York City. We're talking about New York City, New York State liability. It's really interesting. It's called joint and several liability. Technical term, but I'll tell you what it means. You're involved in an accident. There's 2 cars in an intersection. You're a passenger. You sue both cars. One car has the minimum legal insurance in New York, $25,000. The other car has $1 million insurance, okay? So you're a passenger, your lawyer sues both vehicles, and it turns out by the eyewitnesses or maybe security camera footage that the car you were in that only has $25,000 is 90% responsible for the accident, okay? 90%. Oh, the light was yellow, they sped through the light, the other car was there, blah, blah, blah. So most people would determine, or a court determines that the car you were in is 90%. Can you only collect, and they award $100,000 hypothetically, okay? Your car only has $25,000 in insurance. Can you collect the 90 from the car you're in? Well, that's impossible because they have $25,000 insurance. Can you collect the balance from the car that's only 10% responsible? Because on the math, they would only have to pay 10% of $100,000 award, right? That's $10,000. But no. New York State law, joint and several liability. Now, this is a tough one if you have big insurance and you feel that you're not that responsible for an accident. Joint and several means what it says, jointly. Okay, you are liable for the whole ball of wax, even though you're only 10% responsible. Okay, you could be 2% responsible in New York and have to pay the balance, whatever the judgment is. And the plaintiff, the injured party, can choose to collect from either one. And of course, we're gonna wanna collect from the easiest pocket, which is the one that has adequate insurance. Of course, they have rights to go against the other vehicle and collect their money if they can. So the quick answer is you do have the right to collect from both parties if they're to any degree responsible, okay? They have to be 1% responsible to collect. If they're found to have no responsibility, of course, they wouldn't owe anything. So yes, you can collect from multiple parties. You cannot collect, rule number 2, you cannot collect more than the total value of the case. So you can't say, oh, I was paid $100,000 from one party. Can I get $100,000 from the other one? No. If there was a decision that your case is worth $100,000, you cannot exceed $100,000 in collections. But you may have the option to collect it from either party in the crash. Not true if it's not an automobile case, okay? If you are, for instance, if you're involved in an accident in the lobby of a building, an office building, and you slip and fall, and there's a cleaning company and there's a landlord, and the court determines that the landlord is 10% responsible. In that case, there may be no joint and several liability. You have to have an experienced lawyer to look at it. Every type of case has different rules regarding collection. It's complicated. New York law is complicated. That's why get an experienced attorney. Feel free to call me or anyone else. I have no problem talking to clients, asking questions, answering whatever they have. Free consultation. Thank you very much. Good luck.